Section 4. Conditional testamentary dispositions and testamentary dispositions with a term. Article 871. The institution of an heir may be made conditionally or for a certain purpose or cause. Article 872. The testator cannot impose any change, condition, or substitution whatsoever upon the legitimes prescribed in this code. Should he do so, the same shall be considered as not imposed. Article 873. Impossible conditions and those contrary to law or good customs shall be considered as not imposed and shall in no manner prejudice the heir, even if the testator should otherwise provide. Article 874. An absolute condition not to contract a first or subsequent marriage shall be considered as not written unless such condition has been imposed on the widow or widower by the deceased spouse or by the latter's ascendants or descendants. Nevertheless, the right of usufruct or an allowance or some personal prestation may be devised or bequeathed to any person for the time during which he or she should remain unmarried or in widowhood. Article 875. Any disposition made upon the condition that the heir shall make some provision in his will in favor of the testator or any other person shall be void. Article 876. Any purely potestative condition imposed upon an heir must be fulfilled by him as soon as he learns of the testator's death. This rule shall not apply when the condition already complied with cannot be fulfilled again. Article 877. If the condition is casual or mixed, it shall be sufficient if it happens or be fulfilled at any time before or after the death of the testator, unless he has provided otherwise. Should it have existed or should it have been fulfilled at the time the will was executed and the testator was unaware thereof, it shall be deemed as complied with. If he had knowledge thereof, the condition shall be considered fulfilled only when it is of such nature that it can no longer exist or be complied with again. At this Article 878, a disposition with a suspensive term does not prevent the instituted heir from acquiring his rights and transmitting them to his heirs even before the arrival of the term. Article 879, if the potestative condition imposed upon the heir is negative or consists in not doing or not giving something, he shall comply by giving a security that he will not do or give that which has been prohibited by the testator, and that in case of contravention, he will return whatever he may have received, together with its fruits and interests. Article 880, if the heir be instituted under a suspensive condition or term, the estate shall be placed under administration until the condition is fulfilled, or until it becomes certain that it cannot be fulfilled, or until the arrival of the term. The same shall be done if the heir does not give the security required in preceding article. Article 881. The appointment of the administrator or the estate mentioned in the preceding article, as well as the manner of administration and the rights and obligations of the administrator, shall be governed by the rules of court. Article 882. The statement of the object of the institution or the application of the property left by the testator or the charge imposed by him shall not be considered as a condition unless it appears that such was his intention. That which has been left in this manner may be claimed at once, provided that the instituted heir or his heirs give security for compliance with the wishes of the testator and for the return of anything he or they may receive, together with its fruits and interest if he or they should disregard this obligation. Article 883. When without the fault of the heir, an institution referred to in preceding article cannot take effect, in the exact manner stated by the testator, it shall be complied with in a manner most analogous to and in conformity with his wishes. If the person interested in the condition should prevent its fulfillment without the fault of the heir, the condition shall be deemed to have been complied with. Article 884. Conditions imposed by the testator upon the heirs shall be governed by the rules established for conditional obligations in all matters not provided for by this section. Article 885. The designation of the day or time when the effects of the institution of an heir shall commence or cease shall be valid. In both cases, the legal heir shall be considered as called to the succession until the arrival of the period or its expiration. But in the first case, he shall not enter into the possession of the property until after having given sufficient security with the intervention of the instituted heir. Section 5. Legitime. Article 886. Legitime is that part of the testator's property which he cannot dispose of because the law has reserved it for certain heirs who are, therefore, called compulsory heirs. Article 887. The following are compulsory heirs. Number 1. Legitimate children and descendants with respect to their legitimate parents and descendants. Number 2. In default of foregoing, legitimate parents and descendants with respect to their legitimate children and descendants. Number 3. The widow or widower. 4. Acknowledged natural children and natural children by legal fiction. 5. Other illegitimate children referred to in Article 287. Compulsory heirs mentioned in numbers 3, 4, and 5 are not excluded by those in numbers 1 and 2. Neither do they exclude one another. In all cases of illegitimate children, their filiation must be duly proved. The father or mother of illegitimate children of the three classes mentioned shall inherit from them in the manner and to the extent established by this code. Article 888. The legitime of legitimate children and descendants consists of one half of the hereditary estate of the father and of the mother. The latter may freely dispose of the remaining half, subject to the rights of illegitimate children and of the surviving spouse as hereinafter provided. Article 889. The legitime of legitimate parents or ascendants consists of one half of the hereditary estates of their children and descendants. The children or descendants may freely dispose of the other half, subject to the rights of illegitimate children and of the surviving spouse as hereinafter provided. Article 890. The legitime reserved for the legitimate parents shall be divided between them equally. If one of the parents should have died, the whole shall pass to the survivor. If the testator leaves neither father nor mother, but is survived by ascendants of the equal degree of paternal and maternal lines, the legitime shall be divided equally between both lines. If the ascendants should be of different degrees, it shall pertain entirely to the ones nearest in degree of either line. Article 891. The ascendant who inherits from his descendant any property which the latter may have acquired by gratuitous title from another ascendant or a brother or a sister is obliged to reserve such property as he may have acquired by operation of law for the benefit of relatives who are within the third degree and who belong to the line from which said property came. Article 892. If only one legitimate child or descendant or that of the deceased survives, the widow or widower shall be entitled to 1/4 of the hereditary estate. In case of a legal separation, the surviving spouse may inherit if it was the deceased who had given cause for the same. If there are 2 or more legitimate children or descendants, the surviving spouse shall be entitled to a portion equal to the legitime of each of the legitimate children or descendants. In both cases, the legitim of the surviving spouse shall be taken from the portion that can be freely disposed of by the testator. Article 893. If the testator leaves no legitimate descendants but leaves legitimate ascendants, the surviving spouse shall have the right to 1/4 of the hereditary estate. This fourth shall be taken from the free portion of the estate. Article 894. If the testator leaves illegitimate children, the surviving spouse shall be entitled to 1/3 of the hereditary estate of the deceased, and the illegitimate children to another third. The remaining third shall be at the free disposal of the testator. Article 895. The legitim of each of the acknowledged natural children and each of the natural children by legal fiction shall consist of 1/2 of the legitim of each of the legitimate children or descendants. The legitim of an illegitimate children who is neither an acknowledged natural nor a natural child by legal fiction shall be equal in every case to 4/5 of the legitimate of an acknowledged natural child. The legitimate of the illegitimate children, the legitim of the illegitimate children shall be taken from the portion of the estate at the free disposal of the testator, provided that in no case shall the total legitim of such illegitimate children exceed that free portion, and that the legitim of the surviving spouse must first be fully satisfied. Article 896. Illegitimate children who may survive with legitimate parents or ascendants of the deceased shall be entitled to 1/4 of the hereditary estate or hereditary estate to be taken from the portion of the free disposal of the testator. Article 897. When the widow or widower survives with legitimate children or descendants and acknowledged natural children or natural children by legal fiction, such surviving spouse shall be entitled to a portion equal to the legitim of each of the legitimate children, which must be taken from the part of the estate which the testator can freely dispose of. Article 898. If the widow or widower survives with legitimate children or descendants and with illegitimate children other than acknowledged natural or natural children by legal fiction, the share of the surviving spouse shall be the same as that provided in the preceding article. Article 899. When the widow or widower survives with legitimate parents or ascendants and with illegitimate children, such surviving spouse shall be entitled to 1/8 of the hereditary estate of the deceased, which must be taken from the free portion, and the illegitimate children shall be entitled to 1/4 of the estate, which shall be taken also from the disposable portion. The testator may freely dispose of the remaining 1/8 of the estate. Article 900. If the only survivor is the widow or widower, she or he shall be entitled to 1/2 of the hereditary estate of the deceased spouse, and the testator may freely dispose of the other half. If the marriage between the surviving spouse and the testator was solemnized in articulum mortis, and the testator died within 3 months from the time of the marriage, the legitim of the surviving spouse as the sole heir shall be 1/3 of the hereditary estate, except when they have been living as husband and wife for more than 5 years. In the latter case, the legitim of the surviving spouse shall be the specified in the preceding paragraph. Article 901. When the testator dies, leaving illegitimate children and no other compulsory heirs, such illegitimate children shall have the right to 1/2 of the hereditary estate of the deceased. The other half shall be at the free disposal of testator. Article 902. The rights of illegitimate children set forth in the preceding articles are transmitted upon their death to their descendants, whether legitimate or illegitimate. Article 903. The legitim of the parents who have an illegitimate children, when such child leaves neither legitimate descendants nor a surviving spouse nor illegitimate children, is 1/2 of the hereditary estate of such illegitimate child. If only legitimate or illegitimate children are left, the parents are not entitled to any legitim whatsoever. If only the widow or widower survives with parents of the illegitimate child, the legitim of the parents is 1/4 of the hereditary estate of the child, and that of the surviving spouse also 1/4 of the estate. Article 904. The testator cannot deprive his compulsory heirs of their legitim, except in cases expressly specified by law. Neither can he impose upon the same any burden, encumbrance, condition, or substitution of any kind whatsoever. Article 905. Every renunciation or compromise as regards a future legitim between the person owing it and his compulsory heirs is void, and the latter may claim the same upon the death of the former, but they must bring the collation whatever they may have received by virtue of the renunciation of compromise. Article 906. Any compulsory heir to whom the testator has left by any title less than the legitim belonging to him may demand that the same be fully satisfied. Article 907. Testamentary dispositions that impair or diminish the legitim of the compulsory heirs shall be reduced on petition of the same, insofar as they may be inofficious or excessive. Article 908. To determine the legitim, the value of the property left to the death of the testator shall be considered, deducting all debts and charges, which shall not include those imposed in the will. To the net value of the hereditary estate shall be added the value of all donations by the testator that are subject to collation at the time he made them. Article 909. Donations given to children shall be charged to their legitim. Donations made to strangers shall be charged to that part of the estate of which the testator could have disposed by his last will, insofar as they may be inofficious or may exceed the disposable portion. They shall be reduced according to the rules established by this code. Article 910. Donations which an illegitimate child may have received during the lifetime of his father or mother shall be charged to his legitim. Should they exceed the portion that can be freely disposed of, they shall be reduced in the manner prescribed by this code. Article 911. After the legitim has been determined in accordance with the 3 preceding articles, the reduction shall be made as follows. Number 1. Donation shall be respected as long as the legitim can be covered, reducing or annulling, if necessary, the devices or legacies made in the will. Number 2, the reduction of the devices or legacies shall be pro rata, without any distinction whatsoever. If the testator has directed that a certain device or legacy be paid in preference to others, it shall not suffer any reduction until the latter have been applied in full to the payment of the legitim. If the device or legacy consists of a usufruct or life annuity, whose value may be considered greater than of the disposable portion, the compulsory heirs may choose between complying with the testamentary provision and delivering to the devisee or legatee the part of the inheritance of which the testator could freely dispose. Article 912. If the device subject to reduction should consist of real property, which cannot be conveniently divided, it shall go to the devisee if the reduction does not absorb 1/2 of its value, and in a contrary case, to the compulsory heirs, but the former and the latter shall reimburse each other in cash for what respectively belongs to them. The devisee who is entitled to a legitim may retain the entire property, provided its value does not exceed that of the disposable portion and of the share pertaining to him as legitim. Article 913. If the heirs or devisees do not choose to avail themselves of the right granted by the preceding article, any heir or devisee who did not have such right may exercise it. Should the latter not make use of it, the property shall be sold at public auction at the instance of any one of the interested parties. Article 914. The testator may devise and bequeath the free portion as he may deem fit.